In some states, you can write up your own will. I mean, take a pen and a paper and handwrite it up and sign it without anybody around to see what you did. And in some states, that is valid. It's called a holographic will. In Washington state, we do not honor holographic wills if you are a resident of Washington when you create that will. But let's say you lived in a state and when you wrote up your will yourself, that particular state does honor holographic wills. And then you move to Washington. Washington then should accept and honor your will, even though it's a holographic will, because when you created it in a state that allows such wills. Now, is this a good idea? You can imagine my answer is going to be absolutely. It's a terrible idea if you do a holographic will in one state where they honor it and then you move to Washington to expect to rely upon it, because the likelihood is that that will be really scrutinized, probably will cause all sorts of problems, will potentially lead to litigation. It is just not a good estate planning practice to do your own will, handwrite your own will. But what I do want you to know is that holographic wills are good in some states, and if you move to a state that they don't accept it, they should, in the event it was created in the state and the state of origin, honor such a will. So are you confused? You should be confused, because holographic wills will only lead to confusion. Which leads me to my next point. When you move to a new state, talk to a estate planning and elder law attorney in that new state, because what you're going to find is that there are going to be different requirements in the state that you moved into. For example, the holographic will. No estate planning lawyer in Washington state is going to say, oh, you're fine, just stick with your holographic will, because we know it's going to create all sorts of problems. Let's say you move from California to Washington state, and in California you had a revocable living trust, because that is the estate planning tool of preference in California because of their difficulties with probate, costs of probate, percentages that they take of the estate, etc. But you move to Washington, and here in Washington we'll say, you know what? You don't need a revocable living trust. We can even avoid probate without one. You just transfer on death your house to whomever you want to receive it, do pay on death provisions for your bank accounts, that sort of thing. So you can accomplish a similar result in Washington to avoid probate, but without all the hassle of having a revocable living trust. So is that going to be your situation? I don't know. You'll have to speak to an estate planning lawyer, but my point is that every state has its own rules, and what is best practice in the state that you move to. You need to see an estate planning lawyer who will guide you.